right, so welcome everyone to today's webinar, Criminal Convictions in the Hiring Process, presented by Barclay Damon. Many thanks to our presenter, Michael Sciatti, for being with us today, and to all of you who have joined in. Please note this webinar is being recorded to share what we learned with the business community. All attendees will receive the link to the recording. Michael Sciatti will share the presentation with you and then follow with time for questions and discussion. So please use the chat to submit any questions during the presentation. And as a reminder, when others are speaking, please keep your audio on mute to minimize the background noise. So I'll turn this over to you, Michael.
Yeah. Share my screen. Okay, well, good morning, everyone, and thanks for joining in. I'm Michael Sciatti. I'm a partner at Barclay Damon in Syracuse. I represent employers only in the labor and employment field. I've been doing this now for 30+ years. Today, we're going to talk about criminal convictions in the hiring process, and we are entering into a brave new world at the end of this year. New York State has enacted what is called the Clean Slate Law, and I'm going to go over that first. It will impact hiring, and you may not even know about it because certain convictions are going to be deemed, quote, sealed. So that means if you ask the magic question, have you ever been convicted of a crime? Answer, no. And you're probably going to be none the smarter. There are exceptions, and we'll talk about those as we go through today, and then we'll go into the analysis of the criminal conviction and whether it should disqualify the person or not disqualify the person. And I can tell you one of the largest complaints increases that we have seen in recent years are discrimination complaints under the human rights law filed with the New York State Division of Human Rights alleging criminal conviction discrimination. That is individuals who have a conviction, disclose the conviction, and were not hired by you. Can I have an automatic rule that says, hey, I'm not going to hire a felon? No, you can't. Can I have an automatic rule that says, hey, I'm not going to hire anyone with a criminal record? No, you can't. Should I ask the question, have you ever been convicted of a crime? I think you should. I think you are legally allowed to ask a series of questions, and I think it is a disservice to your hiring process if you don't ask all of them. And if the only question you ask is, have you ever been convicted of a crime? If yes, please explain. That's not sufficient. It's not sufficient for you to do the analysis that the New York State requires. And it doesn't really help you to analyze whether or not this person should be hired. Have you ever been convicted of a crime? Yes. What was it? And, maybe he gives a description. There are lots of problems we have seen arise in this area. We'll talk about those throughout the day. If you do have questions, feel free to put them in the chat. As I see the questions, I'll try to answer them, or I'll defer to the end. I will open it up for questions at the end as well. I put my contact information up here in case you do have a question. It's wonderful. We sit here for about an hour or so, but maybe in a couple of days something dawns on you. I should ask Mike this. Just email me. I'll answer the question for you. Our agenda today is threefold. Really, it's twofold, but the third part is one slide. We're going to talk about the New York State Clean Slate Act, the effective date, what it covers, exceptions, etc. I think there's some more information to come on it eventually with guidance from the state of New York. And then we'll talk about the bread and butter here, criminal conviction inquiries under Article 23A. And lastly, we'll talk about local laws and criminal convictions. I just want to point out a few things to you there, that if you're in one of the locations that have local laws, Syracuse, New York City, Rochester, Buffalo, you also have to comply with those laws, and they're different from what I'm going to go over here today. So if you have assets in locations where local laws and discrimination laws exist, you also have to comply with them. Mike, maybe the way for me to handle this is not to ask, have you ever been convicted of a crime? Well, Johnny was convicted in 1980. He served 25 years to life for murder. He served 25 years and was out. And if you don't ask the question, you have hired someone with a Class A felony that did hard time for 25 years in a maximum security facility. I think it is negligence on your part not to ask the question. And that's the other part of the extreme. You can't have the rule that says we're not hiring you if you're a criminal. But I do think you should ask the question and all the appropriate questions, which we will explain to you, because it's more than have you ever been convicted of a crime. And I've seen another version of that question. Have you ever been convicted of a crime in the last 7 years? Well, if you do background checks, the background check is going to be limited to 7 years. That question's not helpful to me either, and it's really worse than the other question because you're limiting yourself. So go back to the example I just gave. Johnny was convicted of murder in 1980. He served 25 years. Your question is, have you ever been convicted of a crime in the last 7 years? Answer, no. He was truthful. You asked a bad question. The other thing we see when we ask the criminal conviction questions is they're getting smarter. This is one that we had. The individual says, have you ever been convicted of a crime? Yes. What is it? Violation of New York Penal Law section, blah, 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 blah. Well, what's that? I said, I don't know. I had to go look. They eventually went and looked after he started working and discovered that he was found guilty of involuntary manslaughter. And when they got into the details of the crime, and we just did a quick Google search and found all the details, him and his friend held someone down and stabbed him. And that was the individual they hired. Not good, not good. So you have to be careful. Sometimes they'll give the penal law section. You don't know what that is. Go look it up or call your counsel because it makes a huge difference, or throw it back on them. What does that mean? And then you're dealing with someone, beware, you're dealing with someone who's very sophisticated. I also want to give you the following name. Richie Levine, spelled Levine. If Mr. Levine applies to come to work for your company, greet him with open arms and say, come on up for an interview. We're not going to do a Zoom interview. We want to interview you face to face. Mr. Levine is a convicted felon. He makes his living suing employers. Thousands of filings with the Division of Human Rights. Let that sink in. And he collects on the vast majority of it. $500 here, $1,000 there. And what he looks for is something on your internet where you discourage individuals with criminal records to apply. You're having some, like background check rules. He's very selective, but and here's the other thing. He's usually right in his analysis. The other thing, he's written a book in this area on basically how to screw over employers. And that book is out there and it's published when people buy it. So be careful if you have to deal with him. So let's jump into this. Let's start with the New York State Clean Slate Act. A recent law passed or signed into law by the governor. It is in the criminal procedure law. I try not to do legalese, but I like to at least identify where these things are for you. It becomes effective November 16th of this year. So beware of that. The effective date is coming. But here's the kicker. The Office of Court Administration has 3 years to November 16th, 2027 to seal all eligible convictions entered before the effective date. This is going to be something that's automatic. It's not going to simply apply to convictions in the future. They are going to take a look backwards in time And if the individual's conviction is eligible for sealing, they're gonna seal it. And that's gonna be a game changer because there are tens and thousands, maybe hundreds of thousands of convictions that this is going to impact out there. But they have 3 years to do it. The other thing you're going to be confronted with is this. The individual may not have any idea that it's criminal record is sealed. And he will answer the question not knowing it was sealed. Okay, and then we have to be a little careful. I'm not quite sure how we're going to handle that yet, but I think since he disclosed it, we're going to take the position it was a criminal record that wasn't sealed because we said in our instructions, if it was sealed, don't tell us. So we'll see how that goes. But we have more to come on this. We have a lead-in period of time. And remember, it is going to apply to criminal convictions looking backwards as well. Some general rules that I put in here for you to take a look at. I think that's something in the chat. Mike, what is the considered eligible conviction? We're going to get to that in 2 seconds. Everyone, I have a list of what is eligible and I have a list of what is not eligible. And one of the things to remember, a entity like a corporation or an LLC can be found guilty of a crime. This law only applies to individuals. So, and there's a whole bunch of other exceptions that I'm going to go through. So the law, once it becomes in effect, will automatically seal certain criminal records after a required waiting period. And we'll go through this in more detail. Typically, it's 3 years after conviction or release from jail for a misdemeanor, and 8 years after conviction or release from prison for a felony. Again, there's some provisos, provided that they maintain a clean record and are no longer on probation or parole. So we'll go through some of these other rules here: probation, parole, restitution, fines, all these other things. Because there are a fair amount of exceptions, all of which seem to make a little sense to me. Mike, why do they do this? Well, you know, let's be honest. If you're a convict and you have a criminal record, sometimes it's hard to get a job. That's why they do this. And so they are following other states that have done this, and right, wrong, or indifferent. This is something you're going to have to live with now as an employee. Okay, let's get back to there are certain circumstances where sealing will not occur. It's basically, you know, if it's public safety, if it's a sex offender, you know, there are certain situations where, you know, this simply is not going to apply. Those with a pending charge who are required to register as a sex offender, individuals who have received a life sentence or have been convicted of a Class A felony like murder, are ineligible to have their records sealed under the clean slate law. There is a exception you're going to see in a second for Class A felonies and drug convictions. So the eligible convictions, everything. Let's start with that. They approach this very simply. It's all convictions under New York state law. Now, let that sink in. I got a couple slides on it. It does not apply to federal convictions, and it does not apply to convictions outside of New York state. So it could be another state, another country, or under that were prosecuted by the U.S. attorney. This law limits the sealing to New York state crimes prosecuted in New York state. So it's everything, felonies and misdemeanors, except sex crimes as defined in the specific part of the penal code, sexually violent offenses, and you know this list is pretty long, so I just sort of summarized it, and all Class A felonies except drug-related convictions. If you remember the Rockefeller drug laws, you know, if you had get a couple of joints, you can go away for 25 years to life under some of the things that were there. So they carved that out. But just remember, it's all convictions unless it falls into an exception, and there are more, and you'll understand how I broke it out in a second. And as I've indicated, only in New York State, it does not apply to federal crimes. So drug-related convictions will be sealed even if they are categorized as a Class A felony. If an individual has both eligible convictions and ineligible convictions. So remember, sometimes when a criminal is prosecuted, yes, we're going to find him guilty of murder in the second degree. However, we also found him guilty of burglary, or we found him guilty of wire fraud or something else that may have occurred. Eligible convictions will still be sealed. Ineligible convictions will not be sealed. So it will be a mixed bag. The individual will have a Class A felony, and you're allowed, you're going to see that. You're going to see whether you hired the axe murderer, the convicted individual that killed someone. So that exists. There are exceptions, and let me just sort of start by this. If you're in what I call a highly regulated field, you have to do certain background checks. Maybe the background check is done for you by the state of New York, and the state of New York says you can't hire Johnny. Those rules remain. None of those rules are changing here. If you're highly regulated and you have to do certain things, that's fine. And if the state of New York tells you you can't hire Johnny, you can't hire Johnny. So they created some exceptions here to get at the sealed records when it's necessary. I've summarized it again generally for law enforcement purposes, for licensing of employment for specific industries where criminal background check is required to be performed. Let me give you an example. I want to be a security guard in a bank. What's my conviction? Bank robbery. I think we can stop that individual from working there. Employment where a fingerprint-based background check is performed. Those of you in highly regulated know exactly what I'm talking about. Extending employment to a person in jobs where they may work in such groups as children, the elderly, or vulnerable populations. Again, highly regulated. We're not going to allow sex offender to work in school. All right, that's just common sense 101, and that does not go out the window here. And then this last one is really three different ones. It's seeking a gun license. I don't want a felon getting a licensed handgun. A commercial driver's license, given the type of vehicle they may be driving. You want someone with a felony DWI conviction that also involved an involuntarily manslaughter conviction to be driving a commercial vehicle. I don't think so. Or where required for public housing to make the housing safe. Those exceptions, I should say, exist. Now, there is a waiting period, as I indicated on the general rule back there. For the record to be sealed, a specific period has to pass. It's 3 years for a misdemeanor or 8 years for a non-Class A felony or the Class A felony that's drug related. So, John, and it goes from the date of conviction, if there was no jail time, or the date of release from prison. So let's just give you an example. Johnny was in local jail for 90 days. For the next 3 years from the date of his release, he has a criminal record that he will have to disclose to you if he applies. At 3 years plus 1 day, he will not. Because why? Because it becomes sealed. And trust me, they're going to be educating inmates exiting on this law. They already educate on Article 23. So some of them will understand it and some of them will comprehend it. The clock starts, given my example, after incarceration is completed or if there was no incarceration from the sentencing date. So those are our measuring points. But remember, you may get these convictions. Why? Because they're inside the waiting period. So you still may see them. They're fresh out of jail. Now, and you know, another thing I just like to sort of tell everyone. There are individuals who will say to you on your application, yeah, I did this. I'm sorry. I was dumb. I was a young kid. I've turned my life around. And they'll go into all the reasons. Consider hiring them. My experience with the individuals that over disclose yeah, they probably turned their life around. More on that to follow, because it becomes it's a very important consideration under Article 23A, and I'll talk about that a little bit more. If the individual is convicted again during the waiting period, you don't get it. He's still a criminal. He has another conviction. The waiting period is reset from the date of the most recent conviction or at the end of the prison term. So if they're bad and they continue to be bad, they don't get the benefit of this law. It resets. What if I am under what I call community supervision? Remember, it's called the Department of Corrections, Prisons, and Community Supervision, parole. The new law is not to be construed to permit the sealing of a conviction before the termination of the sentence of incarceration, or if they're on parole, or if they're on probation, or in some other type of post-release supervision. So they're in a halfway house for a period of time that's mandatory, something like that. So realize if they're still tied to the system, the deadline don't run. So let me give you the example. Johnny is released from prison. He did not serve his full term, so now he's on parole. It runs from the date parole ends in that case. Okay, so there will be some measurement periods here, but again, I think it's only to your benefit because you will learn of those convictions, and you're allowed to make inquiries. If there is an order of protection in place as a result of the criminal conviction, that remains. That does not go away. New York has something called a persistent felon rule. So I did grand theft auto 3 times, a class E felony. Well, the third time, you can be sentenced to 25 years to life because you're a persistent felon. So am I allowed to consider a felony that was sealed under the persistent felony rule? Yes, and that's for the courts, not so much for you. Why? I think it's a public safety rule. You know, we don't want that person who doesn't get it because they're on their 3rd felony to, you know, get the benefit or reward of the sealing. The courts can consider it in the sentencing of whether does he get a reduced sentence or does he get the 25 years to life because he's a persistent felon. What if the criminal conviction ordered restitution or fines or surcharges, something like that? Those remain. They do not go away. The individual will have to pay them back still. Believe it or not, and you probably do believe it, that inmates who are convicted, individuals who are convicted of crimes have lots of recourse. And once they're convicted, appeals and things like that. There's nothing in this law that prohibits a convicted defendant from taking advantage of other things that they can do. And here's a list. You know, a motion to vacate a conviction, to set aside a sentence, to vacate a judgment, a motion for resentence, etc. There's lots of things an individual convicted of a crime can do to try to get a new trial, to try to get the judgment vacated, to try to change, their conviction. So I gave you those examples here. Not really worth time and money to go through them. So what is the impact of the clean slate law? If you have an eligible crime and you're at it runs, the timing is up, meaning I'm off parole, I'm out of prison and there was no supervision, or I didn't go to jail at all. I was convicted, you know, it runs from the end. It excludes certain things. Then what happens? Well, Johnny comes to work for you. His record is either sealed or not sealed. Article 23A will come into play if it's not sealed. All right. If it's sealed, you're not going to know about it because he's not going to answer the question, have you ever been convicted of a crime? But again, remember, if you're highly regulated, you're going to do a background check, the state has to approve it, you have fingerprints, that's fine. You are allowed to keep doing that. Those laws remain. So Article 23A of the Corrections Law. This is the law combined with the human rights law, which prohibits discrimination based on criminal convictions. Here's the nuts and bolts of it. It's discriminatory in employment or licensing to discriminate against someone because they've been convicted of a crime. That is the reason for it. Now there are exceptions, and I'm not. We start with the general rule, but there are lots of exceptions, and there are things that you can consider. So let's assume, what is the impact of the Clean Slate Act? Let's assume none, and the individual applies for a job for you. First, I'm going to give you a series of questions here that I want you to ask. It is not, have you ever been convicted of a crime? That is one of them, but it is not all of them. And if all you are asking is, have you ever been convicted of a crime, you are not in compliance with the corrections law, and that's what I want you to get out of today. The question then becomes, when do we ask this question? This becomes important. There's no New York State law. What we see is the local laws. Rochester, Buffalo, say to employers, dear employer, you can only ask this after you have given a conditional offer. What is the condition? Disclosure of criminal records, a background check, maybe a medical exam, whatever your conditions are. So let's assume one of your conditions is the successful completion of what I call a criminal conviction inquiry form. This is when I think you should make the inquiry. You tell the individual when they apply. If you get past the application, there will be a second application wherein you must disclose your criminal convictions. And maybe you got to have a physical or whatever else it may be. That is when I think you ask it. Can I ask it in the initial application? For most of you, yes. For all of you, not necessarily. If you have assets in Buffalo, if you have assets in Rochester or some of the other local laws, you got to review those local laws. I can tell you unequivocally, Rochester and Syracuse, Rochester and Buffalo do not allow it in that regard. So keep that in mind. Can I, under the correction law, deny an individual who has disclosed a criminal record to me employment? Maybe, okay? There must be a direct relationship between the conviction and the specific employment. What's the one example I already gave you? Johnny wants to be a security guard at a bank, but he has a bank robbery conviction. Yeah, that's silly. That's a real case too. The guy, 25 years ago, he was a walk-in my old office. I was on call that day for walk-ins, and I met with him. He's screaming, I got discriminated against because I had a criminal conviction, but I really was innocent. And I looked at him, I said, what's your conviction? He's like, robbery. And what job did you apply for? Bank security guard. He said, but I was really innocent. I said, did you go to trial? Yeah. Did you lose? Yeah. Did you do state time? Yeah. They said, you're convicted. And they were right to deny it. That's the type of thing we're looking for. Let me give you an example at the other extreme. Have you ever gone to a car dealership and they give you a courtesy ride back to your work or place of employment or home, wherever it might be? And you look at these fellas, and my experience, all older guys, this is sort of their retirement job. Here is Johnny. He applies for a job at a car dealership to be one of these, shuttle drivers. Have you ever been convicted of a crime? Yes. When? 45 years ago, during spring break, I was convicted of disorderly conduct, and he has been clean ever since. I have to hire him. I can't disqualify him because of the criminal conviction. It's so far removed in time and what have you. Now, how about a tougher call? Johnny is out of prison 1 year for bank robbery, and he wants to work as a receptionist in your accounting department. And there are funds there's petty cash and things like that. I think that's a denial. I think that's a denial. But it gets tougher the closer in time the conviction is to when they want to work for you and whether they're clean or not. And you're going to see in a second. You can ask some tough questions, and you can reject an application if they don't answer the question. Say, sorry, you haven't told me the information I wanted, and until you do, I'm not going to consider your application. We'll talk about that in a second. And then the second factor, so it's a combination of the relationship between the conviction and the job. And then the second thing is, public safety, the safety and welfare of the coworkers, the safety and welfare of the general public that may come into the facility. Johnny's an axe murderer. Let's be blunt. Well, I want to work him. That's a tough call. Because he served his time, and I can tell you the state's going to take a hard look at it, but most employers would probably deny it at the end of the day. So again, lots here. Mike, you mentioned if I asked the question, have you ever been convicted of a crime? That is not enough. That is correct. All right. Here are all the factors that you as an employer have to consider. You all should have up in your workplace an Article 23A employment poster. If you were to read it, you would see these factors listed there. If you give a background check, you must attach this to the background check, this Article 23A poster. And when you do the criminal conviction inquiries, I also recommend that you attach a copy of Article 23A. I think it's very important that you do that. So what are these factors? Well, the first one's a little wishy-washy. And just the state of New York doesn't want you necessarily to discriminate on the basis of it. But that's knowledge. You know the law. That's important. Number two, what are the duties and responsibilities related to the employment sought or held by the person? Trust, honesty, diligence. They're going to work alone without supervision, and they're going to be around financial information. But Johnny was convicted of insider trading or something that is financial in nature. Tough call, but we probably will deny it. What bearing does the criminal conviction have on the individual's ability to do the job? You figure it out, a bank robber and a bank robbery conviction. That's an easy one. Now, the next two, employers are afraid to ask. Don't be. The law specifically allows it. The time which has elapsed since the occurrence of the crime. And the magic question, how old were you at the time of the criminal act? Yeah, let that sink in. You are allowed to ask how old you were at the time of the criminal conviction. Now, if I fast forward, what have I figured out? How old the person is. Can I ask how old you are? That is illegal. But this is an exception. You are allowed to ask the individual how old they were at the time of the crime. Why? So you're allowed to figure out how much time has elapsed. So remember that. Those are two questions that people normally don't like to ask. And the next thing that's going to follow after these factors are the actual questions that I think you should use. So hold on, we'll get there. The seriousness of the offense, you know, felony level stuff, I'm really concerned about. One of the things I always want you to watch out for is something called sexual abuse. It's a misdemeanor. It is a catch-all for rape. It is usually used in a plea when the victim is unwilling or unable to testify. So when you see that, your radar should go up, that this person is really, at the end of the day, a rapist, and please keep that in mind. This number 7 is overlooked all the time. Any information produced by the person or produced on his behalf in regard to rehabilitation and good conduct. The letter from the rabbi, the letter from the priest, the letter from the drug counselor, the letter from his mother saying he's changed his life. You have to consider all those things and make sure you save them because you have to consider them. And lastly, and on that one again, there's a couple of others I'll talk about. There is a good conduct certificate or a certificate for release of disabilities that they can get. I'll talk about those in a minute, but those fall under number 7. And then you as the employer have a legitimate interest to protect your workforce and to protect the general public that can walk in. Okay, that is, and this is the balancing test. And you must ask the questions that address all really 8, but it's really 7. You know, that first one is just that you know the law. So let's go through some more detail. If the employee, if the applicant has a certificate of good conduct, it is presumption of rehabilitation. It is a presumption of rehabilitation. That typically means don't consider the criminal conviction. And these things are given out on application, and it's a very detailed application. So make sure you ask for it and make sure you understand the significance of it. We often see employers get into trouble because you forget all 8 factors and you only consider what the crime was. Consideration is required in existence or absence of one factor is not determinative. So make sure one factor does not control. It's an overall analysis. Document, document, document. And I mean this. You're going to see the magic questions in a second. Anything they give you, you keep. The more important, one of the most important things is good notes when you're interviewing. One of my clients was sued for criminal conviction discrimination, and here are the facts. The individual wrote a cover letter, sent out 300 of them for his testimony. The individual said in his cover letter, very long description of his criminal record, what he did. I've rehabilitated, please give me the chance to interview him. Of the 300 resumes he sent out, 299 rejected or did not respond. Who was the silly one? My client. They responded, you know what? We sort of like that letter, and we think everyone deserves a second chance. So they interviewed him. In the interview, this is where good note-keeping comes in. He said the following: I don't want to work here. My parole officer made me send out all those resumes. I really want to do something else. But I had to take the interview because you responded. They basically said, thanks for coming in. They would have considered him, but for his comments. Good note-taking. Keep that in your back of your mind. We're going to come back to it in a second. I want you to review your job applications and questions posed by your managers. Make sure the people that are interviewing know what you can and cannot inquire about relative to criminal convictions. I do management training all the time, and the managers say, I didn't know that. They ask about the person's current salary. They ask about criminal convictions, but they don't ask all the questions. This is one of those areas. You ask all the questions or you ask none. I think there's only one answer. You ask them all. I think that's what you have to do. If you're doing a background check, I already mentioned, you must then give them a copy of Article 23A. I would also insist that you do it when you ask these questions, what I call a criminal conviction questionnaire. Now, this one, please keep in mind, employers get in trouble on this all the time. I am a law-abiding citizen. I interviewed with you and I don't get the job. I call you up. Why don't I have that job? Do I have to give any reason? No, you do not. I am a convicted felon. You interview me, you don't hire me. I call you up. Why didn't I get that job? Different rule. The rule, if you have a crime, is if the individual that had a crime interviews with you, doesn't get the job, you must respond in writing within 30 days as to the reason they didn't get the job. Let's go back to my example. I don't want to work here. We didn't even address, he asked why he didn't get the job. We didn't even address the correction law factors. Answer, sir, during the interview, you said you did not want to work here. We ended the interview. Have a nice day. We still were sued. And it was funny, during one of the conferences with the Division of Human Rights, his comment was, and we were ready for this, he's like, if they have anyone with a criminal conviction, I will withdraw this claim. And I took the packet out and I put it in front of the division investigator. I said, here are the current 9 individuals working for us with criminal records. Here's another package. There's another 18 in here that had worked for us in the past, going back 10 years. I said, so I guess we're done. They dismissed it. But our reason wasn't any of the thing to do with his conviction. Why? He said he didn't want to work here. Now, if it does relate to the conviction, let me be blunt. Counsel writes this letter for you. It needs to be perfect, because if there's any mistake, any omission of any of the 8 factors, it's going to come back to haunt you. But remember this right that they have, unlike anyone else. You also, if you're doing background check, please remember you must continue to comply with all of the federal and state reporting. Let's get a question. Okay, so the question is this. The 30-day rule, that you have 30 days to get it out, only applies when the employer is aware of the applicant's conviction, or all employers required to know each applicant's background. You're not required to know the individual's background. I have always taken the position that it applies when the employer knows about the criminal conviction. However, I've seen this also when I advised the client to respond. They called up and said, you really knew I had a criminal conviction. You didn't ask that question. That's why you responded. I had them do the 30-day letter. The 30-day letter there was very simple. Sir, we didn't know about your criminal record. We never asked. You never told us that after the hiring decision was made. So, but I think it's a fair commentary that it applies only when the employer really knows it at the end of the day. Mike, you promised us the questions. This is what I remember. I said we're going to do this post offer, but before they start working. It's a conditional. It's a condition to come work for us. I call it a criminal conviction inquiry form. Question 1, have you ever been convicted of a crime? Yes, no, not sure. Okay, if no, we jump to the end. And you'll see, I want you to give directions on the form. There should be explanations for the question, some disclaimers, and the impact of failure to disclose, which we're going to talk about. But what about not sure? We get this a lot. Or they try to say, I really don't know. And our response back, go figure it out. When you can answer this question, yes or no, and tell us what you were convicted of, we will be happy to consider your job application. But if you can't, if you're not sure, go figure it out and come on back. They don't like that answer, and they usually don't come back. So it's usually pretty serious. But if it's a not sure, put the burden on them. I would not process this application any further until they're able to answer that question. A couple things here. Explanation of the questions. We define what a criminal conviction is. There is a disclaimer. What's the disclaimer? We don't discriminate on the basis of individuals who have criminal convictions. We follow Article 23A. Failure to disclose. Liar, liar, pants on fire. Have you ever been convicted of a crime? No. He's working for you. 3 months later, one of your employees says, Mike, he's on the sex offender registry. Here's his picture and a printout of his convictions, which is all public record. I fired. What do I fire for? You lied to us. You lied to us on the application. And that's a good reason to determine it. What does convicted of a crime mean? I put it on here. We're going to be tweaking this a little bit to indicate it doesn't apply if it's been sealed. Disclaimer, I would use this language. It's our policy. I call it X's company action. Insert your name. A criminal conviction is not an automatic disqualification. Okay. And you know, just put the nice disclaimer in. Failure to disclose. If you lie to us and we find out later on, we're going to reassess the hiring and you might be fired. Again, totally fine. And I've given you the language. I'm sort of summarizing it real quick for you. Go back to what that question was. Have you ever been convicted of a crime? If no, stop. If yes, or not sure, please see me. And if yes, please continue. For each criminal conviction, don't assume there's one. You see this problem a lot. Leave space. This person might have 10. We're going to have to evaluate all 10. How many convictions do you have? For each criminal conviction, they must be explained separately. If you have, and you know, I put in here, if you have more than one, see so-and-so. They just may need more space. They may need more paper. Oh, okay, that's all I want to know. What was the crime you were convicted of? Was it a felony or misdemeanor? Now, please describe in as much detail. Force the detail. What happened? I also, once you get it back, I want you to Google search it. You'll be amazed what comes up in Google. Maybe I got a question there. If an applicant knows that his or her convictions are sealed, can the applicant legally answer the question? No. Yes, they can. If it's sealed, we're done. It is not fair game anymore. And some people have conditional dismissals. It has to be a certain period of time. You know, if it's sealed and gone, it's gone. And just remember that. To force them to give the detail. All right, it's very important. Don't let them off easy. Oh, got in a fight. Got in a fight with who? When, and was the person injured? You know, where did this occur? When did it occur? I mean, ask the tough questions. I want to know if it's a felony or misdemeanor. They don't know. We'll figure it out. Come back when you have that information. Don't process the application further. Where did the conviction occur? Make them identify the court. New York. No, I'm sorry, sir, that's not acceptable. Texas, Tennessee, California, not acceptable. We need more information. They don't have it. Too bad. We'll figure it out. Come back when you're done. When did the criminal conviction occur? Please provide a month and year at a minimum. Please note, we will consider how much time has elapsed since the occurrence of the criminal offense and the date of your application. And the next question go hand in hand. How old were you at the time of the criminal offense? I add this language also. Please know, company X is not asking for your date of birth. We're just asking for the age. I know you can take that age and fast forward to what their date of birth is. Don't do it. Don't do it. I don't want to see in your hiring notes, oh, Tina's really 39. This is a limited exception. Don't abuse it. You're going to figure it out anyways. Just don't consider it. Next question, very important. Do you have any information you would like us to, that you want to tell us about rehabilitation? Yes. What is it? Please note that this information may be produced by you or someone on your behalf. Consider it. I don't care what it is, a note from mom, consider it in your hiring process. Do you have a certificate of release from disabilities, which is issued typically by a court, where they've taken away the stigma of a criminal conviction, and it creates a presumption of rehabilitation? Yes, I do. If yes, produce a copy. I have a case right now where the individual said yes to this exact question, but did not produce a copy, and we held it against him. He files for criminal conviction discrimination. We're marching towards hearing in the Division of Human Rights. Our defense is easy. Here's the instructions. He didn't give it to us. If he gave it to us, we would have considered it, but he didn't. And since he didn't do it, we held it against him. We think that we're going to be okay. Do you have a certificate of good conduct? Again, please produce it. It presents presumption. And then I like a catch-all. Ma'am, is there anything else you would like us to consider relative to your criminal conviction? Please note you're not required to give us anything else, but if there is something positive you want us to know, let us know. And one of my clients got a very lengthy letter from the individual saying, I was a stupid 19-year-old. I did stupid things. I'm 30 now. I have a kid. I'm a father. I'm married. I've changed my entire way of life. I'm begging you for a job. And this was a food service job. He said, this guy couldn't find a job. Very hard. I know 5 years later, the last time I checked, he's still there. And he's one of their best employees, and he's been promoted to assistant manager. So, you know, that's what this law is trying to protect. Don't be afraid to give someone the benefit of the doubt. Now, let me fast forward. You gave him the benefit of the doubt. He comes to work for you, and he's Satan reincarnated. Fire him quickly. You don't have to give, unless you have someone with an employment contract or there's the union protections. But if you realize, have you ever made a bad hire? End it. I mean, just don't think I got to keep them employed for some period of time. No, you don't. You know, law firms, we've made bad hiring decisions. I remember one back at my former law firm. He'd worked for us during the summer, and great worker. And he comes back, you know, a year later. I didn't even recognize him, and his work habit went from here to non-existent. And he was only worried about what days off he got, and didn't care too much about his legal work. And we really quickly sort of figured out, I don't know what the change is, but you know, you need to improve. If you fire someone, document. If it's not in writing, it did not occur. Can I fire someone for being miserable? Please note the 10. What's it called? A bad attitude. Don't be afraid to give verbal warnings, written warnings. Don't be afraid to do a last and final warning. Don't be afraid to terminate someone. Don't be afraid to suspend someone with or without pay. I'm not a fan of the with pay because it's sort of like a vacation. But you have the ability to suspend individuals at work. But again, it comes down to documentation. I did management training on Monday for a client. They had no documentation. They've been in business 20, 30 years, no documentation. And it was a foreign concept to them, and we had to introduce it to them. So we did this big training on here's this form for you, here's this form for you. And I explained to them, you know, from my perspective, how these forms help you, how to fill them out, and things like that. But remember, good documentation is key. Lastly, and then I'll open it up for questions. We're pretty much at the 1 hour mark. I warned you about this early on. Local laws. There are local laws, and I just listed a few here. Syracuse, Rochester, Buffalo, New York City. Where if you call me, Mike, I have a criminal conviction question, and you're like here in Onondaga County, let's say you're in the town of Clay, but you're not in the city of Syracuse. but you have a Syracuse mailing address. My first question is, are you in the city limits? No, I'm not. Yes, I am. I then have to follow not only the human rights law and the correction law, which we just went over, but any local law the city of Syracuse has. Buffalo and Rochester have very strict laws. If you have assets there, you can only ask these questions after you've given a conditional offer of employment. So what are we are going to expect here? What's going to happen? Well, we've got some lead-in time now, but remember the exceptions here. You're not necessarily going to know a record was sealed. The applicant is going to be able to answer the question, no, I don't have a criminal record. If you find out who really did and it wasn't sealed, you can hold it against them. Background checks, you can continue to do them. Nothing in the law indicates you can't. Please note they're generally limited to 7 years. Comply with all the warnings and waivers and releases that you need to do. But what I really want you to learn from here today, what are the magic questions, when to ask those magic questions, and how to consider everything. Now, I realize I gave you outliers, like the bank robber applying for a security guard. That's an easy one. Those will exist for you. And then there are another easy one at the extreme, the shuttle driver who had a disorderly conviction 40 years ago, and it was a misdemeanor while he was on spring break in college. That's a softball one as well. But they get tougher in the middle. And that's where the legal analysis comes in. That's where I think you need to reach out to counsel and say, I need some help on this one, and develop a plan to attach it. Remember the name, Richie Lalonde. If he applies for employment, thank you for your application, sir. We'd like to schedule an in-person interview. It is on this day and time. Does that work for you? Can I do that virtually? No, sir, you can't. We do our interviews in person. We'd like you to come up. He might schedule it, but he won't show. Please remember that. Otherwise, you will get a love letter from him. It says, you violated the law, $75,000. And let me see the last one, whether he actually listed the last one I got. I usually get, now he didn't list, oh, yeah. In order to resolve this matter, before I file with the Division of Human Rights, send me a check for $1,000. And the one thing that I have hundreds of cases, the list of what this guy has settled for, it's in excess of $500,000 that he's got in this. And he tries to get us to pay his business. I'm like, no, Richie, we're paying you. You got the client. We're giving you $500. You got it. And we're going to fix the problem. I want you to look at your websites and LinkedIn, any Indeed, any third-party vendors you use. Anything you say about criminal convictions must be scrutinized. I want you to train your managers on what you can and can't ask. And this is just, this is a question. There's like 50 other questions that I have we can do a legal analysis on whether you can ask it and when you can ask it and things like that. But other than that, I'm going to turn it over for questions if there are any. And again, if you think of a question in the next day or so, just shoot me an email. I'll point you in the right direction, and make sure you have Article 23A up with your other 2.9 million employment posters that we now have up in the workplace. So with that, I'll turn it over for questions. Does anyone have any additional ones? Okay, I don't see any. I'll turn it back to the chamber for concluding remarks. And if you do think of anything, everyone, again, please feel free to just send me an email. And I think we have our next one coming up in a couple of months, and we'll see you then on our next webinar. Thank you.
All right, many thanks to you, Michael, and Barclay Damon, and to everyone for joining us today. We'll share the link to the recording with you later on. You can always visit chemungchamber.org to register for our upcoming webinars and find recordings of our previous webinars. And please also remember to sign up for our chamber mailing list. Stay informed of our member news, our upcoming events and programming, and many more. And that's also available on our chamber website. And for anyone interested in any additional information regarding the chamber membership, please contact us at info@chipmunkchamber.org or at 607-734-5137. Thanks again and have a wonderful day.